Dear members, good evening. I welcome you all on behalf of the Management Committee for the study circle meeting on the comparative analysis of retrenchment and disclosure of undertakings under the old Act and the new Labour Code, and mastering mergers and acquisitions practical insights for professionals. To speak on the topic, comparative analysis of retrenchment and closure of undertakings under the old Act and the new Labour Code, we have amongst us Advocate Tejaswini, DR. I request Chairman Bangalore Branch, Manjunath sir, to please welcome her, to greet her, escort and welcome her with the floor. Members, a round of applause, if you don't mind. Thank you, Chairman. Members, I would like to briefly introduce the speaker. Tejaswini DR is an advocate who graduated with the LLB, BA LLB degree from the MS Ramaiah College of Law, Bangalore University in 2013. She joined Mrs. King and Partridge on the 1st July 2013 and has been associated with the firm for nearly 13 years. Her area of expertise includes civil litigations, real estate litigations, mutual consent matrimonial matters, criminal laws, white-collar crimes, labor laws, service laws, and employment laws. She regularly appears before all courts and tribunals across Bangalore. With that brief introduction, I request the speaker to present a talk. Members, please welcome the speaker.
Good evening, everybody. My name is Tejaswini. I know this is not an ideal situation. It's the last day of the year. You'll want to, have a good time. But let's also see if we can get something out of this conversation. Now, what we are discussing today are the key legal shifts in the old labor legislation, that is the Industrial Disputes Act, okay, and the new one, which is the Industrial Relations Code. Now, before I go into, we're going to be doing a comparative analysis. Okay? Before we go into what the new code prescribes or what were the differences between the two legislations or what are the differences, let's first go into the history. So you will have here, I'm sure you can see, I won't be able to see it. Now, what is the history of the Industrial Disputes Act? Why did the Industrial Disputes Act in itself come into existence, right? Now, you all know that the First World War took place prior to 1929, right? After the First World War took place, what happened was there was a lot of labor unrest. There was a lot of strikes, lockouts, etc. So what the British government did was, it enacted a legislation called the Trade Disputes Act of 1929. But that was a very short-lived act. The reason for that was, it lacked any effective adjudicatory mechanisms. There were no effective adjudicatory mechanisms. It was not worker-friendly, okay? It was also not focusing on the industrial peace, harmony, which was at that point very, very, very required. So what happened then was, after the Second World War, the British government tabled this new legislation called the Industrial Disputes Act of 1947. Now that was shortly prior to India attaining or becoming an independent country. Right? In 1947, August we were independent. In April 1947, with effect from that day, the Industrial Disputes Act came into existence. Now that's been an act which codified the dispute mechanism for employer, workmen employer-employee related disputes, so that there is some way in terms of mediation, conciliation, arbitration, those kind of provisions were available. Thereafter, it also catered to when is an illegal strike, when is it an illegal lockout. Because what happened was, after the Second World War also, there was a huge rise, or a significant rise in labor unrest. Now what this did was, it translated into a lot of illegal strikes, lockouts. There was no balance between employer-employees, and this further resulted in any strike, any lockout will obviously come in the way of production, because of which many industries had to close down, many industries had to shut shop. This again affected revenue, which is why the Industrial Disputes Act came into existence. Now, while we understand the Industrial Disputes Act, let's also see what the object of the Act was. These are the objects of the Act, right? One is, it promoted industrial peace, which is what we were all looking forward to. We needed industrial peace, we needed harmony, we needed an effective dispute mechanism where it was such that whatever was done, any decision taken by the conciliation officer or the arbitral tribunal, the national with dispute mechanisms in such a way that whatever decisions were being given by whichever authority, whether it was a conciliation officer, the appropriate government, I will go into who an appropriate government is, and the arbitrators, the labor courts themselves, all of them became final and binding. There was a binding nature of all these authorities which actually was lacking in the Trade Disputes Act. So that was sorted. Now subsequently, social justice also, that was another thing that we sought to achieve under the Industrial Disputes Act. The only issue with the Industrial Disputes Act and the other labor legislations were, they are all independent acts. As you all know, they are all welfare legislations. You have a Payment of Wages Act, you have a Payment of Bonus Act, you have an Industrial Disputes Act, Gratuity Act, so on and so on. There were definitions that each enactment had, which were all different. Wages under the Payment of Wages Act was completely different. Wages under the Industrial Disputes Act were different. So there were times when there were clashes, there were contradictory interpretations. Now, in order to streamline all of this, right, and to ensure that you had a unified code pertaining to the very same subjects, you had 4 different codes that came into being. Now, we are concerned with the Industrial Relations Code. Now, in the Industrial Relations Code, you will see, when did the shift happen? The shift happened when, the Industrial Disputes Act became a little obsolete. We were not able to maintain the worker and employer balance that we wanted to maintain. As you know, a society, we were not able to maintain that. It was, most of the times, it was either worker-centric or it was interpreted as completely employer-centric. So there came a situation where we said, okay, let's put 3 different legislations under one umbrella. That is, as you can see there, it is the Industrial Disputes Act, which dealt with all mechanisms. 2, the Trade Unions Act, which governs the registrations of trade unions, their recognition, how they function, what rights does a trade union have to fight for all its workmen and its members. 2, the third one is the Industrial Standing Orders Act. All of these, there were unnecessarily 3 different legislations having different meanings when it could all have the same meanings, because they were all one and the same. They come under one umbrella. Which is why this code came to be brought in and it became the Industrial Relations Code. Now, what the Industrial Relations Code achieves to do is to better balance the employer-employee equation to have a better and more modernized effective mechanism for dispute resolution, and to also help large establishments as well as medium-sized establishments. Of course, my presentation will call them small establishments. I am bringing them under the bracket of small establishments. But it is in effect to help medium-sized establishments. I will also come to the reason why medium-sized establishments are helped at this point, or why they are catered to, how their interests are taken into consideration. Now let's get into the code. We understood the history, the reasons as to why the code came into being, right? Now, what does the Industrial Relations Code target? Whom does it target? It targets every organized sector. It targets private, public, any enterprise, irrespective, even if they are software companies, it targets now. Okay? If you all will be aware, especially in Karnataka, software companies have been exempt till I think about 27 or 29 under the earlier labor legislations. Now all of them will have to be overturned, they will have to be done away with, right? It has to cater to everybody, there has to be uniform applicability. What it doesn't apply to, or which sector it doesn't apply to, is the unorganized sector. Okay. Now let's move on to the definitions under the old act. I'm not going into each and every definition, or I won't read each of the definitions. But what I will do is, I will just give you a tabular column as to what the key differences are. Okay. Now the first thing is industry. When I come to the comparative table, we will see that there is a huge difference between the term industry as defined under the Industrial Disputes Act as well as in the code. Currently, an industry means any systematic activity. Back then, the term industry, its definition was as restricted as this. Anywhere where you are doing manufacturing, you are doing mining, you are doing any such industry, transportation, etc. It was a restrictive definition that was there at that point. I will come to the current definition later on. An industrial establishment was any establishment which did any of this industry. Even a unit, if you had a huge industry, there were multiple units. If any of those units also were undertaking any of the above industry related, this mining, transportation, etc., that itself would be considered as a separate establishment for the purposes of the Act. Okay. Then we go into the important definition of closure, which is one of the topics that we are going to discuss today. Closure is as simple as permanent closing down of a unit, permanent closing down of an entire establishment, either wholly, in part, it could be a department, anything. Now, another important definition is retrenchment. What is retrenchment? Retrenchment is nothing but termination of service of an employee or of a workman. Okay? What does it not include? That is crucial. It does not include anybody who is on BRS, who voluntarily decides to resign, who voluntarily decides to separate. Okay? That is the BRS scheme and BSS scheme. All of these are floated only to downsize. Usually companies float these schemes to downsize their workmen. It doesn't include a situation where you have entered into a contract and that contract comes to an end, or it is not renewed because due to efflux of time it has come to an end. It does not apply to them too. It also doesn't apply to anybody who has continued to be absent due to ill health, so on and so forth. By and large, some of these definitions are the same. Of course, in retrenchment currently, there is something new that I will come to under the code. Then worker. How is a workman defined? A workman earlier used to be defined as any person who was employed, who is engaged for skilled, semi-skilled, unskilled, manual, operational, any such work. It included somebody who was engaged through contract labor, that is directly or indirect employment. It of course did not include anybody through the armed forces, anybody who's, police force and such others it did not include. That also by and large remains the same, except that there is a huge difference to what worker means now. I'll again come to that. Now let's go into the code. What are the current definitions of the code? These are crucial. Industry, if you may see, take a look at the definition of industry. Earlier industry just meant mining, transportation, so on and so forth. Here industry refers to any systematic activity which is conducted or performed by an industry, and it includes any industry which provides services, which sells goods. It could be anything. The definition is very, very broad over here, and it is open to any interpretation. We will have to of course see how that goes, how the courts are going to interpret that. That is something that we will have to see. But as of now, industry is worded very, very broad. The next definition is of course industrial establishment. It's largely similar. We'll go on to closure. Closure is the same. In retrenchment, everything else is the same, except that you will see in point number 4, there's a new provision. Retrenchment also does not include any person who is employed in fixed term employment. What is a fixed term employment? Fixed term employment is where you and I enter into a contract and say, your contract, your services are required for 1 year. Your services are required for 5 years, so on and so forth. That is fixed term employment. That in the event that there is a termination or due to efflux of time the contract comes to an end, in which case earlier it was subject to a lot of litigation, because of which the workers, the person entering into the contract, they were unnecessarily dragged into litigation and they were required to pay retrenchment compensation. We'll come to what retrenchment compensation is. To put an end to this issue, to put a quietus to this confusion, the Industrial Relations Code specifically said, let's exclude any contract that comes to an end in respect of a fixed term employment. So that is a key change that has been made to the definition of retrenchment. Now there's another key change to another definition, that is worker. Worker earlier meant any skilled, unskilled, so on and so forth. Now and another point that you all may want to note, earlier the definition of workman included an apprentice. This definition excludes an apprentice and says that any sales promotion employee as well as a working journalist, all of these people are included in the definition of a worker. Of course, who is not a worker is similar to the earlier definition. That is, if you are in a supervisory or in a managerial position, you are in the armed forces, police services, etc. And earlier the threshold was any supervisor who was receiving wages exceeding 10,000 rupees was removed from the definition of workman. Now it has been increased from 10,000 to 18,000. So the reason why this was done is, you name a person supervisor, you name a person executive, because that is how the policy, the company policy is. But merely by their designation, can you say that they are protected workmen? Now, who is a protected workman? Protected workman under the labor laws is anybody who comes within these definitions. Why are they called protected workmen? They're called so because they have easier access to mechanisms such as conciliation officers, the labor commissioners. The dispute mechanism is a little more closer to them in terms of achieving that, as opposed to a non-protected workman. A non-protected workman If there is any grievance, the only place that he can go to is go to a civil court. And if he goes to a civil court, he will have to pay something called a court fee. These are things that a worker will not be able to financially have. He will not have access. That financial stability is not there for them to go to the civil court. Which is why they are all defined under the definition of workmen, and they are all protected. Because when you approach, when there is a dispute, when you have a grievance, when you go before the Deputy Commissioner of Labour, the Assistant Commissioner of Labour, or even the Labour Inspectors, there is no requirement for you to make a fee. There is no requirement for you to have a long drawn or a cumbersome application. You just write a letter and action is taken. So that is easier access. That is why they are protected workmen. That is the main difference. Now, if you see the definition of worker, it also includes any sales promotion employee. Of course, who is a sales promotion employee is also very ambiguously, I must say, defined in the Act. But that is again subject to interpretation, because there are certain specific provisions that deal specifically for a sales promotion employee. There are certain provisions in the code which specifically deal with a working journalist. So what a sales promotion employee, how the courts are going to interpret them is something that we will have to see as time goes by. Now moving on, to summarize all the definitions, there is this table. What I said in the last 15 or 20 minutes is basically what is captured here. The key industry, there is a stark difference. Here it is a systematic activity, any systematic activity. Here it was only mining, that is the IDA, it was only mining, transport, so on and so forth. Industrial establishment, by and large the same. Closure, there could be no different definition to the term closure. Retrenchment, not much has changed except that it excludes fixed term employees. And workmen, like I said just now, it excludes apprentices, it excludes anybody who has who's a supervisor and who gets a salary or wages of 18,000 and more, and certain other minor revisions are made to the definition of work. Now let's understand what the thresholds of the earlier enactment were. Whom did it apply to? Why is there a threshold in the first place? Right? So the Industrial Disputes Act or any other act, for as you know, they are all divided under chapters, and chapters are each subject wise. Insofar as retrenchment, closure, layoffs, all of these are concerned, there are two key chapters that we need to take into consideration. One is chapter 5A. Chapter 5A and chapter 5B are similar provisions. They all deal with lockout, they all deal with layoff, they all deal with retrenchment, they all deal with closure. But what is the difference between the two? Chapter 5A says that we will make it applicable to any industry having 50 workers or less than 50 workers in the average 1 year, in the preceding 1 year. That is point number 1. Chapter 5B applied to any industry having 100 and more workmen. Now I will come to why there is a difference between the two and what is the difference between the two. Why was there a necessity to have two separate chapters? Chapter 5A, once again, it dealt with any industry or establishment having less than 100 workmen. Chapter 5B dealt with any establishment having more than 100 workmen. Now what is the change in the Industrial Relations Code? The Industrial Relations Code said that look, let's not come in the way of medium-sized or small-sized establishments. Let them also, go on with productivity and all of that. Let them also be able to sustain in the society. Which is why they said we will shift it from 100 to 300. So what the IRC does, this is the major shift between the Industrial Relations Code and the IDA. That is, earlier it was 100, the cutoff was 100 for Chapter 5E to apply. Now the cutoff is 300 workmen. There was a Chapter 5A, there was a Chapter 5B. Here it is Chapters 9 and 10. We will of course go into what these chapters say. Like you all can see here, Chapter 10 of the IRC, these are all special provisions. Like Chapter 5B is a special provision under the IDA. Chapter 10 is also a special provision. All of these are applicable to any establishment having 300 and more workmen. Now, the provisions for retrenchment. This is the crucial difference between Chapter 5A and Chapter 5B and Chapter 9 and Chapter 10. What is the crucial difference? If I as an employer want to retrench my workmen, and under the old Act, I had less than 100 workmen, where Chapter 5A of the Industrial Disputes Act applied, all I needed to do was issue a notice to my workmen. Once I issued a notice, of course my notice had to be reasoned. I'll have to set out my reasons as to why I want to retrench these workmen or a particular workman. Once I do that, I am good to go. I pay them their closure compensation, I pay them their retrenchment compensation, and there is a formula also for that. It is the 15 days average 15 days pay for them. You pay them their compensation. If you don't provide them the notice or you don't issue them the notice, you pay them the salary in lieu of that notice period and be done with it. So that was how it was protected from government interference. That was what Chapter 5A did. Whereas in Chapter 5B, what happened was, if you had more than 100 workmen, 100 also, you had to approach the government by making an application to the government seeking permission to retrench these workmen. And that is a cumbersome procedure. The government would have to conduct an inquiry. It would have had to be satisfied that the retrenchment is not illegal. You are not victimizing these workmen. You are not kicking out a person who has come in first. The whole point of retrenchment, when you are downsizing a company, what you do is you follow the last in first out rule. That is, you protect your seniors. You don't protect the juniors, you protect your seniors. If you have violated that, then of course the government can come after you saying that this is victimization. Which is why there is a difference between 5 and 5. For large establishments, I have set out over here, you needed permission from the government. Of course, we will go into what is the procedure to apply for that permission, what are the consequences of not getting the permission, what are the consequences of violating those permissions. We'll all come into that a little later. But this slide, of course, deals with the circle, as you can see there. Those are the similarities. The similarities are the same, that is, issue notice and be done with it. That is for 60-day notice you have to provide in writing. For the other portion deals with large establishments where there are 300 and more workmen, or rather it says 299, so it has to be 300 and more workmen, where you have to seek prior permission from the government. Now, who is the government? Before we go into all of this, there is something called an appropriate government. Who is an appropriate government? Now, if you are operating out of the state of Karnataka, your appropriate government becomes the state government. If you have a presence in the center, for example, many of these companies like, let's say, maybe ONGC. all of these guys, many of these guys, they are central companies. RBI, it is central. All of these, the appropriate government becomes the state government, the central government. So it is that government that you will have to make an application to. You can't make an application to the wrong government, to the wrong authority. You can't do that. You have to make it to your appropriate government. For example, let's take HMTI. HMTI or the watch company, that's largely a state-run company. It's predominantly in Karnataka, right? It's only in Karnataka. It's also phasing out now, but it's by and large here. So for them, if there is a dispute between their workers and the employer, they will have to go to the government of Karnataka. And if they want to close down their unit or they want to retrench their workmen, they make an application to the Karnataka government. Now let's see what happens once you retrench your workmen. It is surprising that the 1947 Act and the current law had a particular provision where if you retrenched your workmen, you as an employer were obligated to give them about a year's time. If you were re-employing somebody in their place within 1 year, you were required to re-employ them. So it's something like the workers, they had a right of first refusal. That is something that nobody has followed till date, and I don't know why. Because I think people just lost sight of this provision, and the fact that there is no consequence that is appended to this provision, nobody bothers now. If you see any of the employers, they will just retrench. But do they actually provide an opportunity to their retrenched workers and say, look, I've retrenched you, I'm employing some more people within that 1 year's time only, it's not beyond 1 year. I want to make an offer to you. How many of them do that? I don't think anybody is doing that. And my personal opinion is that obviously if there is no consequence appending to these provisions, it is just a provision, it's just on paper. But this is something that is actually worker-centric. It's not just retrenching them. You're also giving them an opportunity to introspect, think back, better themselves and get re-employed. You're not leaving them high and dry. That is what sections 25H at that point and the current 72 sought to do. Now what's new insofar as retrenchment is concerned? Why is retrenchment being talked about today? The Industrial Relations Code said, let's be more worker-centric and let's bring in something called a worker reskilling fund. Now what does the worker reskilling fund do? It basically says that okay, I will retrench you, you upgrade your skills and you come back. For that, I will pay you 15 days average last drawn salary, I will pay you that money, I will put it into your account and you upgrade yourselves. But my personal view is that if the reskilling fund was brought in such a way that there was a scheme where the employer could have a contribution fund, they could help the workers in any way to upskill themselves by creating some workshops, programs, because as of now we know that AI has come. Not everybody, many of them don't want to understand what AI is because they're in their old ways. But that is something that is going to be here around for a long time. Let's take it as an example. If that's the case, then should we not give them an opportunity or have a workshop of sorts where you force them to understand what AI is? I'm only using AI as a hypothetical situation. It could be anything else. Anything to upgrade yourselves. That is something, because tomorrow whatever machines that you use, manufacturing industries, they use a whole lot of heavy equipment. All of these machines tomorrow will be run by AI. You may not need manual operations at all, but you will need to know how to use it. And workers who are on the shop floor of these factories, They are the ones who operate these machines, right? So it is for them to understand all of this. They have to upgrade themselves. What this reskilling fund does is, you take their 15 days average wages, put it into their account within 45 days, there ends the matter. For a worker, it's just additional money. Why is he going to do anything about it? How do you know he's going to upskill himself? He's not going to do that. It's just additional money. Instead, the law could have said, no, I will create a workshop for you guys. Which according to me, I don't know how it's, maybe it's something that will eventually come up. Maybe they will amend it. We don't know. Now coming back to what fixed term employment is. What we discussed earlier, fixed term employment is you and I have a contract. We say that you work for 1 year, you work for 5 years, etc. What is the impact on retrenchment? The main impact is that earlier what used to happen is it was all open to litigation. If you and I had a contract and your term came to an end, it was treated as retrenchment and it was challenged in the court, and you are unnecessarily dragging the employer, right? Instead, now what it does is, they made it very clear, abundantly clear, that fixed term employment should be left out of the retrenchment. It is not treated as retrenchment, it is just termination of your contract by efflux of time. What that does is, that removes the strain on the employer. So if you see, there are some provisions that are worker-centric, there are some provisions that are, also helping the employer. There now is some sort of a balance between employer and employee relations, employer-employee disputes. Of course, we will have to see how this goes. This is just on paper. How much it is implemented is something that we will definitely have to see. Now I've made another comparison table just to summarize what the main differences are. Like I said, applicability threshold, it is for Chapter 5B under the old Act was 100 workers, now it is 300. For government permission, you need to have, under the old Act, you were required to have 100 workmen, now you are required to have 300 workmen. Then retrenchment notice is by and large the same, 1 month notice. Then fixed term employment, like we discussed earlier, it was subject to a lot of litigation. There was a lot of grey area over there. Now it is very clear. And the next is the benefit that you have got, that is the reskilling fund. Then we move on to closure. Now what is closure? Closure is just closing down a unit, an undertaking, a particular department. All of that is closure. Under the old Act, again Chapter 5A, Chapter 5B. Chapter 5A said, you issue a notice to your workmen with the intent that you are going to close down your unit with effect from this day. So you are in effect en masse retrenching your workmen. That is in effect what it is. That's the reason why the closure compensation payable is the same calculation as it is for retrenchment. Retrenchment is maybe a handful of workmen. Closure is en masse retrenchment. The entire set of people, you are asking them to go. You are leaving them high and dry because you are closing down your unit. Which is why the compensation payable is the same as what it is for retrenchment. The math is the same. Now, of course, I am only going to stick to Karnataka. The Karnataka rules, the industrial dispute rules, provided for a particular form. It's called Form Q. You filled in that form and you put it in the conspicuous part of your industry. You gave it to your workmen. You told them that I am closing down with effect from today. I will pay you salary in lieu of notice, or I will give you that notice, notify you so that you can make alternate arrangements. After the threshold of 100 workmen, what they had to do was, they had to seek permission from the government. If it's in Karnataka, of course you go to the state government, make an application. Back then, applications were very cumbersome, it was physical, right? That is another change that I will come to. The Industrial Relations Code has moved with time, of course, saying that you can make a digital application also. And you can make an application in any other manner that is prescribed. Of course, the rules are not yet out, so we still don't know what that is going to look like. The most important thing for closure was that even now it's the same. Under the IDA, it's the same analogy. Here also it's the same. You cannot, as an industry, say that I am going to close down my unit because I am undergoing financial difficulties. You cannot say that I have undisposed stocks. You cannot say that this is all beyond my control. I do not have the bandwidth to pay them. You cannot do that. You cannot say on any of these grounds that I am going to close down my unit. Irrespective of your situation, you are required to go on. Of course, if there is a legitimate reason where, for example, in one of my clients' cases, they incurred loss from day one. I don't know why they run that company for 9 years. Subsequently, a lot of people came in between. A whole trade union issue happened, and the president of the union created a lot of hue and cry. He was an outsider. These workers were actually getting paid decently. All innocent fellows, they ended up being brainwashed, and finally they all lost their job. This closure was challenged before the court, saying that no, they are just victimizing all our workmen. They are going to employ contract labor workers and perform all the work that permanent workers do. They challenged it. We went ahead, we appeared in the matter. We said that no, we're not doing anything. Look, I don't have anything left. I'm in fact disposing of my raw material. I want to shut shop and go. I don't have a presence in India. I'm a Dubai-based company. I don't care what I do here. I'm not going to do anything beneficial for the workmen. It was not just purely on financial difficulties. If I had argued only on financial difficulties, I perhaps wouldn't have succeeded. I made it clear to the court that it's not just financial difficulties. I don't want to have any presence here. I don't intend to do business here. That is a right for me to close down my unit. Nobody can force me to run an undertaking as a going concern. That is for sure. The courts have said that no government, nobody can come in the way of your decision to continue or close down the unit. Having said so, it has to be compliant with the provisions of the Act back then, now the code. What happens if now it is of course 300 plus workmen, earlier it was 100 plus workmen. What happens when you make an application? When you make an application to the government, the concerned appropriate government, the first thing that will be done is an inquiry will be conducted by the government where all parties, that is the employer's side, the worker's side, as well as any other interested person will be heard. Once that is done, an order is passed. Either the permission is granted or it is refused. Now, the order passed by the appropriate government, either way, that is whether it grants it or it refuses to grant it, it is valid for 1 year and it is binding. This is the binding nature that I was talking about. Back then, the 1929 Act of Trade Disputes Act, that lacked binding nature of decisions, which is why the Industrial Disputes Act came into being. Here, the government's decision becomes binding, but the government has the power of review. It can review its own order on its own, suo motu, or on making an application saying that, boss, you review your order. It can also say that, okay, I will review it, but I am not clear on what I need to do, so I will refer it to the concerned tribunal. They can do so also, the government can do so. But once it gets referred, it will have to be adjudicated within a prescribed period of time. And whatever order has been passed, it has to be communicated. That is fair. The only thing is, there is no appellate mechanism that is available for refusal of grant of permission. You can perhaps just file a writ petition and see how that goes. There is no dispute mechanism or an appellate mechanism for an employer where permission itself is not granted. And we will also come to what are the consequences of not granting permission. There is another concept of deemed permission. What happens when the government sits on itself and says that, okay, I'm not going to say anything for the next 60 days. You don't hear from the government for the next 60 days on your application. Then the law says, back then also it said the same thing. It says that you have deemed permission. There's a deeming fiction that is provided for in this provision, which basically says that if you don't hear from the government on your application, you are good to go, you can close down the unit, and that cannot be questioned as illegal. That was there even in the old law, that's there even in the new code. Now once we've dealt with the provisions for retrenchment and closure, when is it said to be illegal? Who can make an application or who can make a challenge to the retrenchment order or the closure order that has been passed by whichever authority? It is a protected workman. Like I said, who is a protected workman? A person who comes within the definition of workman under the old act, worker under the new act. All you need to do is go before the Assistant Labour Commissioner, you make a representation saying that this is what has happened. He is a conciliation officer, he will call the employer, he will say, is there a way that you can settle this matter? If as an employer I say no, there is no question of me settling this, then it gets referred to the government as a dispute and it becomes an industrial dispute. There, the employer or the employee will seek declaration that the retrenchment is illegal or that the closure is illegal. Okay? And they will have to show proof as to why they are saying that retrenchment is illegal. How do you say it is illegal? One is, you don't issue that mandatory notice. You are required to notify them because you are putting them on the road. Practically you are saying, please go. You need to give them some time to make alternate arrangements. Right? If you don't give them notice. If it is more than 100 workers under the old act, now 300, if you don't seek permission, then it is illegal. Two is, you don't follow the last in, first out rule. You decide to send a senior because you say, okay, he is quite senior, he earns more, we are unnecessarily paying him more, let's ask him to go. Because the younger generation is far more hands-on on all these things. You can't do that unless your contract says to the contrary. If in your contract you have agreed that I am not going to follow the last in first out rule, then it is okay. But in the absence of a contract saying so, you are duty bound as an employer to go ahead and follow that policy. In the absence of which, there can be a challenge to that in the court, and most often than not, you will not succeed as an employer. Of course, you don't pay them compensation, that is no-brainer. You don't pay them compensation at all, or you improperly pay them compensation, that is again subject to challenge before the court. Now similarly, for illegal closure, you have to give them notice for closing down, you have to give them the 60-day notice. You don't do so, or you don't get the permission from the government, that is again illegal closure. You don't pay them the compensation, improper compensation, that again. The third aspect is, you close down the industry, or you close down the establishment or a unit or an entire unit purely to victimize. Now how do you come to this conclusion that it has been done to victimize? That is something that the courts will see. Now it's all circumstantial based. There is no, in these kind of matters you don't have documents to show that this is how it has happened. What you do is, for example, I close down my unit today and shortly after in the very same industry, say I am into manufacturing of steel and all of that, I immediately on the next day or maybe a week or a month's time, I set up another unit. I employ perhaps some of my contract workers. I employ fresh workmen. Thereby, I am victimizing my earlier workmen. That is something that the courts will eventually see through. Whatever you try to do, the courts will eventually see through. But having said so, the courts have also held that merely because you have closed down one unit, it doesn't stop you from opening another unit in a different industry. If it's manufacturing itself, then yes, the courts will have a problem with that. But I have a manufacturing industry somewhere, then I open a warehouse for something else. That is not barred. That is not illegal closure. Right? So that is something, is how the courts have interpreted. How do you come to a conclusion that the closure is illegal? Now what are the consequences? If the closure or the retrenchment, if it is treated as illegal, one is it could be treated as illegal because you have not got permission from the government. If that is the case, from the day you close down, whether even if it is refused, it's the same thing. From the day you close down, it is treated as illegal closure, which basically means that you reinstate everybody, you bring back all your workers and you have to pay them something called back wages. You have to pay them, for example, today I closed down my unit, I don't have the permission, and 5 years later, there is an order saying that the closure was illegal. For the last 5 years, whatever each workman would have got with increments, with benefits, with ex gratia, with bonus, with PF, with gratuity, everything I have to pay it back, and with interest. Right? It's a huge financial blow on a company if a company is not careful while dealing with these provisions. If they blindly retrench, if they blindly close down without following these provisions, this is the financial liability that they are going to have, which is far reaching. Even if you say, I will go to the appellate court, I will file a writ petition, I will go to the Supreme Court. Finally, even if the Supreme Court 15 years later says that the closure was illegal, you will have to pay back wages all the way for the last 15 years with interest. That's a huge financial implication of the company, right? Now, what are the penalties? Apart from being subject to litigation, saying that, you go before the court saying it's an illegal closure, you go before the court saying it's an illegal retrenchment. Now, what happens if you don't get your permission? We'll go to the code itself. The penalty is quite heavy, okay? It runs into lakhs. If there is a subsequent offence, it doesn't say maximum, but 20 lakhs is pretty much what you will have to bear. This is over and above your other financial implication of paying them their back wages and other benefits. Similarly, for closure also, if you don't issue your notice, again, it's not too expensive, but okay, it's 50 to 2 lakhs and stuff like that. But fine, at the end of it all, is not a solution to this. It's only deterrent. As a company, your larger issue is the financial liability that you will have to pay all these poor workmen. You have put them on the road. You will have to give them all their back wages. You may have to reinstate them, or if they are all gainfully employed, by which time maybe in 5 years they will all be gainfully employed. If you are able to prove in the court that all these people are gainfully employed, even then you will have to end up paying them their benefits. Now, summing up what we spoke today, the key factors, the key takeaways are: one is there is no more flexibility now. It is not restricted to 100 workmen. There are about 300 workmen, which is a large establishment. 300 workmen If you have more than 300 workmen, you make, there is a government intervention. Before that, anything till 299, you don't have the government intervention. So it is easier for small establishments and medium-sized establishments to, have a better work culture. They don't shy away from continuing their business. They don't shy away from, having operations, etc. The next is the financial implication is a lot more now because of the reskilling fund. You are not just paying them the retrenchment compensation. You are also paying them an additional amount of the 15 days wages in the last, the average 15 days wages in the last drawn salary. You will have to pay them as a reskilling fund. That is an additional expense that you have as a as an employer. That is something that will have to be taken into consideration. The next most important thing was fixed term employment. Fixed term employment, we are aware now. Another crucial thing about fixed term employment, it of course has nothing to do with the two acts that I am talking about. But as you all know, gratuity becomes payable when I have put in 5 years of continuous service. I am eligible for gratuity when I have put in 5 years of continuous service. But in fixed term employment, you don't have to wait because your term perhaps is only 1 year. So even on completion of 1 year, you are entitled to gratuity. That is a crucial change that has been made. That is of course under the gratuity legislation. But since we are at this topic, we are on this topic, I thought maybe we should also address this. Now the only thing that I am thinking about, maybe of course this is not my expertise, it is probably something that you all will have to figure out. This reskilling contribution fund, this payment, what do you, in your books, how do you show it as? Of course, as CAs, you will all be able to be in a better position to figure out whether it's a salary expense, whether it comes as a perquisite. That is something, there is no clarity on that. I'll leave it open-ended. Of course, I don't have the expertise to say anything about that. So that is something that you will have to see what it is bracketed under. Of course, it can't be, it's not part of wages as defined, the provision that deals with wages, the definition of wages. It specifically takes away any retrenchment compensation, any retrenchment benefit. Perhaps this is treated as a retrenchment benefit. So I think you all will be in a better position to figure out what the book should portray this as. I think here we come to an end with our talk. If you all have any questions, please let me know.
In the case of counting the number of workers, whether the contract workers also to be counted?
Yes, so there is a grey area, but position of law is quite clear now. What it is your clerks, your permanent workmen and your contract workers. Especially those contract workers who you have employed for such a long time that they are as good as regularized workmen. There is still a dichotomy between that. The High Court says each High Court has a different view on that. But in my opinion, even contract workers, especially because many industries, it is unfortunate that they make use of contract workers and those contract workers end up doing the work of the permanent workmen. It's as good as the same. They are equally skilled. If you see the differences between the two of them, there is not much. Which is why there is one school of thought which says that contract workers should be included in the counting of the number. Some say that it shouldn't be.
But is it included in the new code?
That is not addressed. That is again subject to what your judgments say. That is something that they should have made it clear. But the thing is, we can consider worker, the definition of worker means anybody. It includes a person who is directly or indirectly employed. Now when you say indirectly employed, it means through contract. That is the definition of a worker. So going by the definition, it should include the number of workers, because what is used is you need to have 300 or more workers. And going back to the definition, at first blush, it is clear that contract workers are also to be included in the counting.
In that case, if you want to give notice, how will you give to the contract workers? See, for closure, we'll have to give notice. When the contract is employed through the contractor, how will you give the notice to all the...
You will anyway be paying them PF. PF will,
No, PF...
you will have their details.
No,
You will anyway have their
Just
details.
hold it. If the contract worker is contractor is registered under the PF separately, then it is he is paying. Even ESA is he is paying. You are nowhere directly concerned. Only except for a principal employer.
Correct.
So there is a PF.
If I am the principal employer, I will have the details of all these contract workers. At the end of it all, they are working for me. Through the contractor, yes.
And
I have to, if not, I give it to the contractor himself.
I think that
I issue a notice to the contractor himself.
That also mandates that you need to take the details of all the contract workers, PF and all, whether the contractor has paid or not. Otherwise, if he has not paid, the liability falls on the
Yes.
employer. So in that case,
At the end of
so in
it
that
all,
case you will have all the details.
at the end of it all, a contractor is working at my behest. I am the principal employer. I am just engaging contractor because he has manpower. He has access to manpower which I don't have. But I am paying everything. I am paying a huge amount towards PF. I am paying, of course, I may not write it down as okay, I am paying this person this much. That is something that the contract worker will have the nitty-gritties, he will work it out. But I am paying their salaries. The contractor is just disbursing the amounts. In fact, recently I had a case slightly interesting on gratuity, which basically said that under the payment of gratuity, under the old Act, the first instance is on the contract workman to pay the gratuity. If the contract workman doesn't pay gratuity, then it is the principal employer who will be held liable. In my case, what happened was, I had a contract with the principal employer saying that I will pay gratuity, but you have to reimburse me. The contrary to what the Payment of Gratuity Act itself said. What this meant was, you are putting in a lot more financial liability and responsibility towards workmen on the principal employer. Because a contractor is only doing the job for you. You can't have him pay your amounts. You will set up a gratuity fund, you will set up an EPF, you may have a trust or you may be connected to the department, the PF department, you may have an ESI code. As a contractor, I will also have all these. That doesn't mean I become his principal employer. Which is why it is mandatory when you issue that retrenchment notice or closure notice, it is required that the employer, the principal employer is the guy who has supervisory control, who, again it goes back to who is the principal employer. Employer could mean even a contractor, yes, but the liability is on whom? As a contractor, if I pay even the retrenchment compensation, etc., I am entitled to recover it from the principal employer. That is a battle between me and the principal employer. At the end of it all, principal employer will have to pay, either directly or indirectly.
And this 60 days notice is only to the government, not to the worker. It should be 30 days, no?
30 days notice, we have put it up.
Yeah, because to
It
the
is 30 days notice.
workers 30 days, whereas to the intimation to the Factories Act to government.
To the government, for
60
closure, it is 60 days.
Form Q is answered for 60 days.
Yes. Because Form Q is not issued only to the, it is just put up in a conspicuous place. But you also issue that Form Q, there is a letter that you issue to the concerned department. You issue a letter to the Assistant Labour Commissioner saying that I am going to close down this.
Yes, that is 60
That has
days.
to be 60 days.
Whereas in the case of worker, it is 30 days.
We usually consider 60 days only because for retrenchment it is 1 month. It is 30 days for retrenchment. For closure we consider 60 days. When one of my clients' undertaking was being closed down, I told them you give them 60 days notice. Because that is what is provided. You give the government also 60 days, you give the worker also 60 days. Because you are closing down, it's not mere retrenchment. There is an en masse retrenchment of workmen that's happening. and to ensure that smooth transition takes place, to ensure that everybody gets paid. It's a huge process, and the employer anyway needs enough time to collate all the details so that they can pay them their compensation. That itself takes time, which is why there is a 60-day period provided.
Definition of the worker, so employee not a supervisor role, but earning more than 18 months.
So
will it come under the worker or employee?
Okay. So, like, I'm not sure if you were there in the beginning. Now, as a company, I can have designations for my workers. They may, after all, be doing worker-related work, but I call him a supervisor. Unless I am able to show that this person who is in the supervisory role, one, he has people reporting to him, okay, and two, he earns wages exceeding 10,000, which was under the old act. Now it is 18,000. Only then am I removed from the definition of worker. Until then, a person who is in any supervisory role, even if he has one person reporting to him, but if his salary is less than 18,000, he continues to be protected under the labor laws. That is a protection that the government gives him.
And if he is not in supervisory role and earning more than 18,000, he will not be treated as a worker.
No. So, anything beyond 18,000, you can't consider them as, by and large, your worker, skilled, unskilled, none of them would be earning less than, more than 18,000, usually, most often than not. Unless you are able to show that someone is actually doing manual work. Manual labor, they are on a daily wage basis, right? Even skilled, house skilled. If it is anybody exceeding 18,000, it should come within the bracket of employee. Because definition of employee is also there. Of course, I haven't gone into that definition. Employee is also defined. Each of these codes define who a worker is. It defines who an employee is. So they come within the definition of employee. There is a bracket there also under the definition of employee. And of course, any managerial administrative role, they are anyway protected. They are not protected.
Establishment who has more than 300 employees. If you wanted to retrench even one employee also, this is applicable.
Yes.
Application to the government.
Yes. There is no cutoff. It's because retrenchment is, it could be one person, it could be two people, it could be how many other people. It's not laying off in terms of you are firing X number of employees for or workmen for downsizing. Even if it is one single person, and in fact 300 workmen not at the relevant point in time. In the last 12 years, even once, last 12 months, even once, if you have 300 workmen, today you may have 250. But in the last 12 months, at some point, say in May, I had 300 workmen. Even if my current strength is 250, I will have to make an application to the government, seek permission.
Establishment having multiple locations, different states, so they need to apply to the central government.
Yes, they will apply to their respective governments. They will apply to their respective state governments.
Respective state government.
Yes, because their rules will be different. An entity can have work here. It can have work in. It can have an industry in Bombay. It can have an industry in Delhi. They'll all be subject to their respective state legislation, unless you're like an RBI, which is a central. It's a central body. Where I think even BEMEL, for that matter. Let's take an example of BEMEL. BEMEL is also a central government associated entity. So for all of those guys, the central government becomes their appropriate government. Anybody else, like for example, if you say Infosys has presence all over. They go to their respective state governments. because they are not connected with the central. It's not under a central enactment.
And this general question, like now, do we need to wait for the rules to go through these industrial development reports to be implemented, or
No, it is implemented as of 21st November 2025. It's in force. Insofar as the rules are concerned, until Karnataka comes up with rules, you follow the older rules. Because everything says to be prescribed by the government. Of course, the government will have to come up with rules. Until then, you follow the old rules. It is in effect, it is out and about, it is running. You have to start complying with the relevant provisions, because what this enactment has done is, by coming into force, it has in effect partly repealed the earlier enactment. So the earlier enactment doesn't stand unless there is a saving clause, unless you come within the bracket of the saving clause. You can't go under the old enactment.
the old acts has been repealed already?
Yeah, they're all repealed.
I think PF Act is not repealed.
They are all repealed to a certain extent.
Certain extent, PF, ESI.
Everything.
They're given
Your gratuity, everything.
Gratuity not repealed. PF, ESI, they maintained it with this, as law, up to the date of it is.
Yeah, it is there, what I understand. PF is
They're all there in the saving clauses. If they all come within the saving clause, only then they are protected. But as of now, if you're a new industry, you're up and running, you start following the codes. You don't go back to the older. Of course, they can't nullify the acts that have been, any action that has been taken under the old, the PF Act and all of that. Those procedures, everything remain the same. If you see now, earlier what used to happen, you had one entire code for the PF Act. The PF Act itself was like a code in itself. Now what they have done is, in all the social security code, what they have done is, they have brought everything together. They have brought PF gratuity, they have brought ESI, everything has come under the same umbrella. The mechanisms are one and the same. But your schemes will remain the old schemes.
And wages has been redefined under the ESA Act. It is for, recently it has come about.
Yes.
Wages,
Typically,
we'll have to take the ESA.
typically an FTA is excluded from the retrenchment provisions at the close of work when the service gets completed.
Yes.
But if the employer wants to lay off an FTE within, say, that 1 year period,
It's a termination of contract.
it would be a termination of contract, but all these provisions apply.
It won't.
It won't.
A fixed term employment is based on a contract, right? There are contractual terms. When there is a contract, there is also a termination clause in your contract saying that if I terminate the contract, then you go before so and so, so and so, so
The
and so.
reskilling fund is supposed to be maintained with whom?
The employer is supposed to create a fund. He has to make contributions to that fund, and as and when they are retrenched, within 45 days, that 15 days wages has to immediately get credited into their account.
And has to be used for?
That is not at all available.
But the
That is in fact what
But the procedure has not yet come, no, for creating the funds.
No. It has not come. All of that will have to be notified.
Yes, until
Will
then,
have to be,
All of that will have to be notified. But what the provision says is that it is clear. You retrench a person, you keep aside a contributory fund. You start making. If you are right now an industry, you start provisioning for that contributory fund, like how you have a gratuity fund and all of that. As and when they are retrenched, that amount, 15 days wages, last drawn salary, will have to be credited into the respective accounts.
so that's supposed to be used for this.
It is ideally supposed to be used, which is why I said,
Otherwise it's just
yeah, it is just another financial liability for the employer. Unless it had a scheme where it said that, okay, we will have a workshop, where we are actually skilling them, we are upskilling them, we are upgrading their
It's
skills.
meeting the purpose, it's meeting the objective.
Yes.
So there has to be,
I'm sure there has to be some, amendment. Their intention was okay, it is good, but they didn't, think this through. In fact, Chairman and I were having that discussion just some time back, that this is a huge loophole. Merely by crediting some 15 days wages, it's just money for them. Those workers will take it and go. How are they upskilling themselves? And instead, what they could have done is, the employer should mandatorily put all of these guys into a program or a workshop, and at least 120 days, 30 days, or whatever. Give them an opportunity to upskill themselves, understand where they are wrong. That would make more sense. Just by crediting this money, I don't.
You mean we'll have to pay directly to the workers?
Yeah, it has to be credited to their account.
Ma'am, just now you said that FTE will not come under this act because there is a fixed term contract. A contract is there.
Only retrenchment.
Retrenchment will not come because there is a contract, and in between. With an employee also there is a contract. When you come to an employment, you sign an employment letter or contract. That is also a contract. So I couldn't understand what is the difference between the two. There are also terms and conditions are there for employment as well. Similar kind of rates. The only difference is the periodicity. Here I have mentioned 1 year period. There I may not mention a period. That was
No. So there are two different concepts under all these codes. One is an employee. One is a worker. If you go back to the definition of worker, now you are not going to sign any contract, you are not going to have an appointment order. Very rarely will you have any terms. The basic terms and conditions is always there. What governs all these workers is their standing orders. There is something, the earlier legislation, it was the Industrial Dispute Standing Orders Act. There is a key difference between how I treat an employee and how I treat a workman. Now, when I have X number of workmen, I have to necessarily go before the concerned department. I have to get my standing orders certified. And where do you get the standing orders? Standing orders is provided for in the earlier act, which is also going to be the same thing under the new. There is a model for it. You have to stick to that model. That standing orders basically are the working conditions that includes, if misconduct is, if there is a misconduct, how disciplinary action should be taken against these workers, what is the kind of access do they have for these, dismissal and those kind of things. All that is provided for in your standing orders. Whereas an employee, I enter into a contract, I have a service regulations, or I just have my contract. The terms and conditions of my contract, my code of conduct, all of that binds the employee. For a workman, everything is as per the standing orders rules. So there is a difference between the two concepts itself.
right. And one more question was that basically on FT you touched upon gratuity. Just for my conceptual understanding, is there any formula that has been changed? Like for a normal employee, it is like 15 by 26 into number of years. If it is a fixed term contract, will it be the same 15 by 26 into 1? Typically, he will get 1 month money as gratuity.
That's all.
Okay.
Or the number of years that he's had that contract.
No,
Because
but the contract is for 1 year. I
No,
may
you can
choose to
renew.
renew it. I can renew it. Then will it be 2 years that will be counted?
Yes.
Or every year, since this is a fresh contract, I'll just get 1 month.
No, so
once?
the eligibility, if you see, there is a difference even in the Payment of Gratuity Act as well as the new provisions. What it is eligibility is one thing. You are eligible when you put in 5 years of continuous service. For an FTE, you are eligible when you put in 1 year of service. But when is it payable? It is payable to you, 1, either on death of an employee, 2, on attaining superannuation, 3, termination, resignation, whatever it may be, even if it is due to efflux of time. So if an FTE and I have a contract which has been getting extended for say 5 years, the gratuity becomes payable only on the 5th year.
Got it.
But eligibility is 1 year.
I got it. My question was that say 12 months I have entered into a contract. That day, now I am eligible. There is a right, you may choose not to extend, not to extend. At that point in time, will I get the gratuity money or I can demand, or I should wait for the company to decide upon whether they want to extend and then wait for the year 2. Say they may give an extension for 1 more year, they may choose not to give as well. Because
Yeah,
it's a fixed thing.
if they choose not to give, you are going to get all your terminal benefits, including that 1 year's worth of
And if a
gratuity.
company wants to do something, or even if I'm an employer, because I want money upfront. So I may ask the company, okay, just do this one for year one, wait for some time and again do a fresh contract. Don't say there is an extension.
That will become a fresh contract.
That will become a fresh contract, but in a way
Then there is no, you can't treat it as continuous service. It stops at that, then again you start calculating your gratuity for the next year.
Okay.
There is no continuity of service.
So if a new contract is entered, then it terminates. If it is the existing contract gets an extension, it will be treated as a continuous.
Yes. It depends on how you, how you enter into that contract.
Right, thanks.
Yes.
There's a change in the definition which I have given for the wages. There's a change in the definition which I have mentioned in the act.
Can you just turn it on? I'm sorry.
There's a change in the definition which I have made, right, in the new act. It says basic plus DA and whatever the retaining allowances should be 50% or more, right, out of your total earnings. Now my question here is, let's say if you make a performance bonus, right? Now this performance bonus, do I need to calculate in the total earnings? Because I'm not be knowing whether I'll be giving this performance bonus to the employee.
Performance bonus is not treated as wages. It is excluded from the definition of
So
wages.
in the total earnings, we should not consider this performance bonus.
You will not consider it for your basic plus DA plus 50%. It doesn't come within the definition of wages.
Okay.
If you see the definition of wages, this has been the case even prior. Any bonus, any HRA, travel allowance, conveyance, any retrenchment benefit, compensation, any of this, all of this is excluded from the definition of wages. So that doesn't come within that formula.
Okay.
So neither in the numerator nor in the denominator.
It is a separate. I think I don't know how you all show it. It's what salary expense or perquisite. I think that's what.
No, it
I don't
comes
know
as a
how.
salary expense only. You show everything as salary expense, whether in the name of HRA, conveyance, whatever you give it.
Yeah.
It is come as a salary expense in the P&L. So that is how it has been shown in the financial accounts. But while calculation, as you mentioned, that this should not be considered. So when I considered 50%, what his question was, technically in the denominator and neither in numerator, to determine that 50%, this should not be considered. This is something over and above which you have paid, which is not considered in the wages.
Yes. This was the position earlier also.
I got a difference. See, the 50% concept comes only for the exclusions. If the total remuneration and if the exclusions is more than 50%, add back that excess back to the consideration the eligibility.
I think yesterday when FAQ was issued by the Labour Ministry, giving some example, I have to go through it, maybe yesterday or day before yesterday, I think it's on the website, on how to calculate this gratuity and all. By means of some 18-20 questions they have put it and they have clarified what will come, what will not come, and how the computation has to happen.
No, the act is very clear.
No, I think that is clarified in that.
Whatever, they cannot clarify over and above the act. Be clear. Clarification is only a clarification. They cannot override the act. That's very simple. It says exclusion should not exceed 50% of the total remuneration. If it exceeds that 50% of the total remuneration, add back that one to the considering the gratuity, leave encashment, whatever the terminal benefits, whatever. It is other way of saying that 50% of my basic DA exceeds, I keep cut. No. Wages includes everything which is payable directly in terms of money value. And the exclusion should not be more than 50%. That's a simple.
Anybody else? Yes.
If a company has an arrangement with the consultant, and consultants are almost governed by an employee only, so will that be covered under FTE?
Yes, according to me, yes. I've seen, for example, of course, this is under the old Act, Karnataka High Court judgment, where it involved a CA. Okay, that CA was working with that company for quite some time. Whether the question there was whether he was also entitled to certain employment benefits and all of them. and whether the question was whether he could be regularized as part of the company itself, as its employee itself. The court, Karnataka High Court said yes, you have to. Even if he is doing professional service, he is providing professional service, like for example an in-house counsel. You may call him a consultant, you may call him, okay, he's on retainer, whatever the case may be. But he is providing you services from day one to so and so. Which means they are entitled, you are treating them as an employee of the company. Therefore, they are entitled to all their benefits, including whether it was gratuity, whether it was, of course, advocates don't get gratuity and all of that. But other professionals, they do get.
So typically all retainership contract will fall under FT if I go by you. If there is a retainership contract between an individual and the company, will fall under the definition of FT.
If that is what is the nature of the terms. If it's a fixed term employment, that
There is a fixed
where
term,
there is a
typically it is like 12
contract,
months. 12 months contract you enter for a
it
retainership.
comes with
business.
an FT.
If I keep your firm for 12 months as a retainer,
Firm may not come, but as an employee, individual it should come.
You will just become my client.
but they are eligible for the benefit.
No, as advocates, I myself am not entitled to any
No,
benefit.
his question is that if the firm has been taken as
No, that's not how it works. If the firm engages, say my firm, it has been engaged by, for example, you sir, and for the last 10-15 years, I don't become a part of your entity, you don't become a part of my entity. For example, I'm talking about an in-house counsel. Let's take an in-house counsel. An in-house counsel may be somebody who is not barred from doing outside work. He also does outside work, he also does the company's work. He is on the rolls of the company, he is getting some remuneration from the company, irrespective of what that nature may be, even if it is a contract or whatever it is. The Karnataka High Court then said, even if it is professional services, then you treat them as your employee, you give them all your benefits. In that, if I remember correct, it was the CA in that judgment that I was looking at. But this kind of retainership, it doesn't work out that way.
But if there is an individual who is involved, then typically it will work.
For example,
if I enter into a retainership agreement with one of your employees directly, say agreement is with my company and that employee of yours, and I have said that this person I need for 12 months to support me, then will it not work now?
it won't. The nature is very different.
No, but this is a one-to-one agreement. It's
Proprietorship.
No, not every one-to-one agreement becomes FTE. No? It all depends on the nature of your contract.
Correct, madam, if it is a proprietorship, your firm is very large. If it is a proprietorship firm.
Correct.
Even then, merely if for example, if I'm a individual practitioner, okay, we are on retainer, okay, but that doesn't mean I become part of your entity or you, or there is a fixed term employment. There is no employment. I'm only providing services. No,
It is
there is
same as
the
FTC.
employment.
It is same as FTC, fixed term contract.
No, for example,
example
let me
is-
see let me give you an example of a fixed term employment. Okay, for example, let's see, under the Factories Act, you are required to have some health officers, welfare officers, and all of that. Okay, each factory of a certain strength is required to have minimum 1 or 2. Now, if I want to employ these guys, I will do it on a fixed term employment basis. How do I go about doing it? I issue a advertisement calling for, like how these tenders and all you have, no, they call for employment, railways and all, they call for employment. That person succeeds. He is a successful person and he finally bags the contract. Then, that is a fixed term contract. There, he is an outsider, he is not part of my own company, right? He is performing work in my premises. I am giving him some remuneration. Between an individual practitioner and a retainer, where is that kind of exchange? It is only services that we are providing.
No, I can argue with you on this point only. Say suppose that medical officer itself is having his own practice.
He is not allowed to. Usually they are not allowed to.
Yes, I think they will also have the normal working hours what the company is having. They should be bound.
Yeah. They'll be bound by
They
those.
will be bound by
They
those.
are in fact bound even by, sometimes they are also bound by disciplinary action.
Yeah. So in that case, it will
They're as good as the employee
It's
itself.
different, but you are
Yes,
just calling it
the nature of the contract, it's just a contract. Okay? Between you and me, the only thing is there is a contract. Okay? But everything else is the same. You are bound by my rules, you are bound by my regulations. Tomorrow, you are answerable if you misbehave, if there is a misconduct, then you are answerable to me.
Many government organizations
Yes.
for particular projects like World Bank will have a lot of projects.
Yes.
They call professionals, skilled professionals for a particular time period, but they
Yes.
are very much bound to the
Yes.
employment rules.
Yes, that is in fact the context that I mentioned to you about the CA, where it is a long time association, where it is so that you are on the rolls of that company. You have to be on the rolls of the company. That company should be paying you a remuneration for the work that you are doing. Then it becomes an FT. I think we have to wrap up. So, I think we've answered as much as possible. All right. Thanks.
Members, you can take all your questions offline when we are at the canopy for IIT. Thank you, Tejaswini here, for a valuable session on the labor laws. It was clear, practical, interactive, and very informative. We truly appreciate your time and insights. I call upon Chairman Manjunath M. Allur to present the memento to the speaker as a mark of respect and gratitude. Members, we will have a short 10 minutes break and we will reassemble for the next session. Thank you. Members, welcome back. We are now having the session on mastering the M&A practical insights on for professionals. I request Chairman Manjunath M. Allur to escort the speaker, R.Subramoniam. And please offer the floor bouquet. Thank you, Chairman. Now I have the privilege to introduce the speaker. R.Subramoniam is a seasoned finance and accounts management professional with over 35 years of experience across corporate finance, statutory compliance, taxation, direct and indirect, including payroll, internal audits, and administrative operations. He is currently serving as a manager to the Vice Chancellor at ICFAI Foundation of Higher Education, Bangalore. Known for the strong operational leadership, regulatory expertise, and stakeholder management, he has successfully driven financial discipline, ensured statutory adherence, and supported senior management through robust MIS and internal controls. A multilingual professional, he is a proficient in leading accounting and ERP platforms and recognized for the achievement of zero debt recovery. So with that brief introduction, I request the speaker to take on.
Good evening, everyone. It's good to see everyone. Being in a vibrant city and on a New Year Eve. Thank you for that. And thank you for the opportunity to Manjunath sir to speak about this important aspect of this one on M&A. Before moving on, let me give you a further introduction about me. Basically, I was born and brought up in Kerala, Trivandrum, Kerala. And after my graduation, I worked for 5 years in a non-banking finance company, which includes credit operations also. Later on, I moved to a financial services company, with almost 14 years of experience. And after that, I had a stint of 5+ years with a startup, IT years. They are into IT years. And first close to 7 years, I am with ICFI. Basically, I am heading HR and taking care of the Pro Disease office. This is my background. So, I will start with some quote. Wall Street is the only place that people ride to in Rolls Royce to get advice from those who take the subject. Isn't it interesting? So in the Bangalore context, you can replace with either BMTC or Metro. And the second quote, sometimes your best investments are the one you don't make. Any guess? Guess who has written it? Recently become famous for all the wrong reasons. Any guess from the students? I will tell you, it's our own Donald Trump only. He has written it. And there are some other quotes on the merger is when two companies become one, and everyone wonders where the job just become zero. And in an acquisition, the buyer sell it as a synergy, and the seller call it as a survival. Because for his survival, he is selling it. M&A 1+1 carefully modeled to equal 3 and often end up being 1. Nothing builds team spirit like a merger announcement followed by no immediate changes expected. Day 1 of the merger, new logo, same coffee with fewer people, means downsizing. So before diving into the details, in this Indian context, in fact, in economy, even though it's actually, when you compare the overall GDP, it's negligible. But why M&A is important? Any guess? What happens if a company is merging or a bigger company acquires a smaller company, either vertically or horizontally?
Competition.
Yeah, to some extent to competition. The major point is in everywhere, India is considered as an investment destination. Okay. FIS, more FIS. See, when this M&A activity is picked up, the company will consolidate its positions, its market shares. Somewhere you will be there in the corner, limelight, it will have limelight, and operations will improve, this thing. And also overall sentiment will pick up. To back up that, I will share some of the data. This is as per the London Stock Exchange report. See, total deal value is 61.3 billion. That is 50% year on year, and highest in 2022. Number of transactions is increased by 9%. Okay. Key drivers are, as I told you, domestic consolidation, energy transition, portfolio management, and strong role of financial sponsors in the insurance, tech, and healthcare industries. Top sector is energy and power. 20.5 billion USD. That is increased by 33.4%. And 16 year-on-year growth. Other leading sectors, financials, 8.8 billion, Healthcare is 6.5 billion. Breakdown. Domestic is 44.8 billion, which is up by 138% year on year, highest in 2022. Inbound is 10.1 billion. That is a little bit a worrying factor. What is an inbound, especially from students' side? What is an inbound M&A deal? Can anyone try? Inbound is like our foreign what you call the investment coming in India. We are getting dollars. And outbound is 5.8 billion, that is 74% year on year. PE backed is 11.6 billion. It is also showing us a very good growth. Despite the this one, whatever the tariff for, top cross-border partner, both inbound and outbound, are US only. And coming to the investor and banking fees, it is 653.8 billion, that is also up by 22%. M&A activity is 159.3 billion, that is up by 56%. Syndicated lending is 90.1 billion, that is 60%. And the equity capital market underwriting was 272.7 billion, and debt capital market underwriting is 131.7 billion. So these are the positive figures. This is up to H1. Even Q2 is encouraging. Q3 is very much encouraging. And as per the experts, they are predicting some 30% increase in the M&A deals with overall improve our economy. So before moving this one, in this what you call that, in this presentation, we will discuss about one what you call that success case, one failure case, and one for what you call, you can say it as a precedence, has taken over a sick or near bankrupt company, and within 2 years he has turned it around, and he has documented it in a way of book. So these three we are going to discuss. Okay. So these are the definition of merger. I think you are all experts. You know the meaning of export. What you call that, merger, acquisition. Friendly on hostile is nothing but arrange and love marriage. And horizontal, vertical. A big company consolidating a lot of operations among themselves. Statutory merger, a merger initiated by statute. Subsidiary merger, target company subsidiary of the acquirer. And consolidation, both the entities form a new company, requires fresh valuation, and that setup, company setup. Why merger and acquisitions matter in India? So it is driven by rapid economic expansion and market access, faster deal, increased demand, timely due diligence for ease of doing business, and IBC norms got changed. These are all the factors. Regulatory liberalization and policy support. See, more compliance advisory is required, and generally rules relaxation. And the sector-wise consolidations. And innovation, valuation comparables, shift valuation guidance, these are all the synergies with risk mitigation, integrated financial and operational synergy aims. Regulatory liberalization and implications for transaction advisory. Regulatory reforms reshape the deal timelines. See, after the opening up of what we call that 1991, lot of liberalization was done in fact. And IBC 2016 I cited about, they have done some changes. And on the right side, there is a sequencing and compliance. Challenges and outlook of mergers and acquisitions. Regulatory risk, integration pitfalls, and what you call that growth areas for you professionals. Regulatory, what do you call that, scrutiny and changing compliance standards. Governance risk highlighted by Sony C failure. Post-deal integration, complexity across the businesses. And what opportunities you are having, projected 15% M&A growth in 25, which is going to increase to 26% to 30% for the next year also. And not only that, most of the 50% of the analysts, they have predicted 7% growth in GDP for 2026 and also 2027. So in India, key approvals and filing has primarily governed by Competition Act 2002 for merger and acquisitions. The Companies Act 2013 for the corporate governance and compliance, and the SEBI regulations for listed companies. These are the three major, what you call that, regulatory, body. Competition law merger and acquisition, the Competition Commission of India requires mandatory pre-merger notification and approval for the transaction that crosses the below mentioned threshold. Enterprise level assets, what you call less than 2,500 crores in India, or turnover INR 7,500 crore in India. So if combined assets is less than 1.2 billion with at least INR 1,250 crores in India, or global turnover of USD 3.75 billion with at least 3,750 crores in India, the filing is required. Group level assets 10,000 crores in India or turnover 30,000 crores in India. And the details, if the global, what we call that group of assets, US dollars 5 billion with at least INR 1,250 crores in India, or global turnover US dollars 15 billion with at least 3,750 crores in India, filing is required. And deal value threshold, transaction value INR 2,000 crore, and the target has substantial business operation in India. SBO is met if the target has specific user base, gross mercantile value or turnover thresholds in India, example, is more than 500 crores or 10% of the global mercantile value. Key exemption and triggers. De minimis exemption. Transactions which are typically exempt if the target enterprises has assets less than 450 crores in India or turnover or less than 1,250 crores in India. This deal value threshold expansion trigger overrides the de minimis exemption. Even a small target must be notified if the deal value exceeds 2,000 crores and the significant beneficial owner test is met. Green channel, an automatic deemed approval mechanism for transaction with no horizontal, vertical or compensatory overlap between the parties involved. Companies Act and SEBI, the General Compliance and Governance, various other approvals are also needed. CSR regarding the corporate social responsibility required for the companies with a network of 500 crores or the turnover of 1,000 crores or the net over of 5 crores during immediately preceding financial year. Appointing a company secretary mandatory for the companies for the paid up share capital of 10 crore or more. Related party transaction, these also non-disclosure led to many of the M&A failures. The listed company, this would require prior shareholder approval. SEBI regulations require specific information to be placed before the audit committee and the stakeholders. Most of your professionals must be aware of it. Open offer. SEBI takeover code. An acquirer must make an open offer to the public shareholders if they require 25% or more of the shares or voting rights, or acquire more than 5% in a financial year while already holding between 25 and 75%. Final resolution. Special resolution passed by the company must be filed within the ROC within 30 days. Navigating these requirements involves coordinating between the multiple regulatory bodies, include the CCI, SEBI, RBI, and NCLT. And coming to the deal structures, in fact, and the payment methods. Sorry. Stock purchase. Liabilities of the buyer inherit the seller liabilities and contingencies unless the novation occurs, which is enacted by any legal agreement. No step up in the asset basis at the company level. Capital gains for the stakeholders. Approvals, shareholders approval threshold, target disclosures which are critical. Balance sheet continuity of the assets and liabilities and minimal revaluation at the buyer books. Modeling scenario for cash, stock, hybrid affecting the purchase consideration and EPS dilution. And this regarding the asset purchase, liabilities buyer picks specified assets and assumed liabilities inviting legacy exposure. Then asset step up allows higher depreciation and potential risk, in fact. Approval, asset sale approval, creditor contracts and statutory disclosure, that is also required. Balance sheet buyer records and the purchase price seller realizes on the basis of profit or loss of sale. Modeling allocate the purchase prices across the asset classes and stimulate the timing and the cash flow impact. See, then we move to Ultratech acquisition of India Cements. See, I worked in this, financial services arm for around 13-14 years. And this deal was done quickly without any major hurdle because of their general business ethics. I can cite an example in fact. See, when the best performance branches are being looked at for annual awards and rewards, the criteria is not only the net profit, how much profit you earn. They will look at the issues faced, in fact, client complaints and your recovery, this one, that will give more weightage. So they consider with 10 lakhs of profits with good records will be considered over and above 20 lakhs of profits with lot of issues. And and one more instance of their you can say that in 2002-2003 they faced a lot of difficulties for funding. Ultimately, ICICI has agreed to fund. In the last minute, there was some issue because of the government change in Tamil Nadu. So, ADMK period, there was a rift in fact, and the deal was called off. Then it was ready to fund it once again after giving the roadmap and this one. It took almost 1.5 to 2 years. And they have never retrenched anyone. More than 2,000 workers, they have paid salaries for 1.5 years. Many of the employees are working for more than generations. So these are all the business ethics which was easy for the facilitate the Ultratech acquisition by the Aditya Birla. And positive aspect is the strong market presence in the south. And capacity production expansion, that was also one of the reasons. Cost synergies by by combining the procurement and other thing, there is a lot of benefits for them in fact. Infrastructure alignment demand tailwinds in fact. And CA focus integration and timeline is asset market, assess the share market price impact, capacity integration plan, and the timeline to raise the projected synergies. So this is the background. In 1998, India Cements, led by Srinivasan, executed India's first hostile takeover, you might be knowing, acquired Rasi Cements, where they have burned their, their fingers in fact, and have paid much higher premium. And Vishnu Cement, in the open market purchase and with the promoter deals. The 3.8 billion deal advised by DSP Beryl Lynch made India Cement second largest cement producer in India. This was about in early 2000. In 2024, Ultratech Cement gained control of India Cements in stages. In June, 23% stake from Radhakrishnan Damani and Associates in a 1900 crore block deal. In July 2024, bought an additional 32.72% from Srinivasan family, roughly around 3,954 crores. By December, secured 55.5% majority, making India Cements a subsidiary, and Srinivasan has stepped down. This has happened. See, normally they are very conservative because of his age. For the past more than 10 to 12 years, he has assigned to oversee the company to his daughter Rupa Gurunath. What she has done is she has hired an IAM, and wherein most of the old timers has left the organization who work for generation, second or third generation. Many of the person have left recently. So she doesn't, but there are some other issues, market, issues. Due to the issues, she has agreed to hire off. If Srinivasan is younger, you would not have allowed to take over by anyone. See, before that, this Damani has, from 2015 to 2020, he has acquired around 22.76%. And basically there was a talk that that time this price has moved up. There was a talk that he might be trying to buy out India Cements. But basically later on he came to know that for investment purpose he got a good deal also, good amount also. In 2024 he sold. And the exit marks as a key step in the sector consolidation with Ultrasemco cementing control of India Cements. But see, if you compare the capacity, it's just 11% only, but they have got a lot of presence in India. And they own, mines in Indonesia and Australia, coal mines in Indonesia and Australia. So a lot of asset base. Even here, all of their, I work in the financial arms. We are house in Milford House. Previously, you might have heard about this old corporate next to one office building is there, Milford House. So India, they have a one place there, and opposite that Somerset apartment, they have around 5-6 flats, which basically they are using it for guest house purposes. So they have built up asset base across India. Most of the places are their own place. And it is an undervalued company, so cement stocks in fact. You see, I know many operators have approached him, the chairman, basically to jack up the prices, which most of the North Indian companies will do. But he has not agreed for that. So this is how this, in this slide you will see how this Ultrasemco have funded by buying their stake in fact. And the price was very much, now it's around 420 or 430. 22.77% was acquired at 268. They have used their internal accruals and a part of debt. Subsequent promoter purchase in July 2024, the promoter incremental to they wanted to reach up to 55 or 60% of the holding. So, which is very much mandated, open offer price was 25% from the current market price. They have quoted very much higher, in fact, 390. So, this was done through combination of purchase and consolidation of promoter holdings. Open offer and public, holding impact. Mandatory open offer triggered the public shareholding adjustments order as per the SEBI, this one. Offer price aligned with the mandatory mechanics. It's the same, this thing, how he has done, take place he has done it, but in a different way I have shown it. This is a time bomb. January, by 25th, the entire thing was finished and management restructuring, everything has happened. And next is the post-acquisition scenario. See, what the projection was by Q1 2026, by March 2026, they will turn into black, this India Cements alone. But it is in the line, it will happen. And as per the schedule, it will happen, in fact, it is in the line. As I told you, there is no major complication with, as far as CCA, any of the regulatory issues with this one. So the deal was done very quickly. Unlike, there is a say that it will take 4 to 5 years, and this deal got done very quickly, in fact, simply, majorly because of the regulatory and compliance issues. And the next one is the negative part. Italy, Zoni Italy, failure. See, timeline agreement to its termination, 2021 to 24 is the major period. The root cause was basically financial discrepancies and governance issues, and there is a leadership impasse, termination fee and settlements, and lesson to be learned is we need to deepen the financial due diligence. Align with the governance conditions early. These are this thing. Pre-regulatory approvals, you should give emphasis. Lesson include leadership contingency clauses, and lesson to strengthen the dispute resolution and escrow mechanism. So what has happened here is that in 2024, where India media sector, a stark reminder to the procedure pitfalls in the insolvency resolution, highlight the evolving risk in the cross-border and distressed asset deals that as of current December 11, 2022, there is no major new failures reported in Q4 to 2025 and in a stabilizing economy. That is a positive sign. This announced a transformative 10 million deal to consolidate India's fragmented media segment. The merger between Sony Pictures, Networks India, now this Culvermax Entertainment and C Network Enterprises (SEAL) aim to create a powerhouse rivaling the Disney Hotstar, Netflix. That was the main aim for their takeover. He was having 50 plus channel, 1.2 billion viewer, reach, valued at 82 per Z Entertainment shares. It promised synergies, a content production and streaming. C5 plus Sony would have been a wonderful thing, but however it did not materialize. However, after 26 months of negotiation, the deal imploded in January 2022 due to the toxic mix of financial woes, regulatory scrutiny, and ego-driven leadership battles. The fallout triggered arbitration, a 90 million termination fee from Sony to ZL, and a mutual agreement settlement happened in August 2024, where both sides dropped the claims. This is the event-based, in fact. Right from 2021 September till the end. the main, after the CCA approval, then IDBI Bank filed an NCLT petition for 150 crore recovery from SEAL. From there, the problem has started. And then SEAL settled IndusInd Bank, NCLT, informed of the resolutions. Resolves one petition, but scrutiny intensified. After that, scrutiny has intensified. NCLAT overturned the NCLT order. That was also one of the triggers. Questioning the stock exchange approval. And key impact was appellate back in merger back on the track. And then SEBI was Puneet Goenka and Subhash Chandra from directorial roles over fund diverse allegation to the tune of 200 crores. The result was the leadership crisis erupts. Sony privately expresses concerns. Next, 23rd August, 2023 August, Mumbai NCLT approves the merger scheme. Judicial nod, but contingent on the SEBI resolution. That was the impact. And then on 2023 September, Asset Finance appeals NCLT approval in NCLTF over creditor rights. Further delay, NCLAT hearing schedule. And then in October, SAT lifts SEBI ban on Goenka despite the ongoing probe. Sony pushes for NP Singh as CEO. Partial relief, but leadership deadlock. 2023 November, Sony demands contract guaranteeing Singh's role amid Goenka's probe. Negotiations soared. SEAL Subhash Chandra resisted. And December 2023 deadline lapses. Parties enter a 30-day grace period for the extension talks. Public statements, the outcome was a public statement affirmed in good faith the discussion. In 2024 Jan, Sony terminates the deal after failed extension, cites unmet condition. The conditions was not met. SEAL shares plunges 15%. Faced a 2,000 crore market capitalization loss. And Sony agreed to pay 9 billion fee as a settlement. So mutual settlement, all Singapore, what you call that arbitration claims withdrawn with no further penalties. Closure, but still the scar lingers. The reason for the failure, your role will be important. SEAL net debt exceeded 20 billion by a legal enforceable contract, hit 1.5 million subscriber losses, which translate to 20% of the revenue drop, and cricket rights cost 4,000 crores. Regulatory and governance hurdles. In June 2023, the SEBI order alleged siphoning off via SL Group loans, and there are about 20 plus compliance breaches, delayed disclosures, insolvency petitions from lenders, amounting to 1,000 plus crores in claims, eroded the trust. And there was a leadership impasse. Original agreement named Goenka CEO, but Sony backed post SEBI bar demanding Singh's NP Singh. So Chandra's family controlled 26% stake. And then ultimately the market dynamic. Streaming boom devalued, linear TV deal synergies eroded as seen the EBITDA fell down by 40% to 800 crores. Aftermath and financial impact. Seal market how to literally they have reduced to 50%, 7,000 crores by mid 2024. Major layoff, 1,200 plus layoff, which is translate to 15% of the workforce. In Q1 2025, revenue was down 5% to 1,900 crores. Restructured debt via 2,000 crore right issues. We wanted to see originals. Sony avoided 1 million integration cost paid and paid 90 million termination this fee, but retained India's operations. Example, acquiring a stake in Sun TV. No major stock hit actually globally. Sector ripple, media M&A chilled. And then Reliance Disney talks accelerated, closing in 2025 as 8 billion rival entity. Legal cost 50 million in arbitration. Singapore tribunal ruled in Sony's favor, or some claims before the settlement. So this is the scenario. So lessons learned, as you told, due diligence depth, extended financial audit to 6 to 9 months for volatile sectors, stress set for OTT disruptions. That also you can have a look at it. Governance alignment, pre-signed MOUs on leadership conditions, involve independent directors early. In the initial stages itself, I will predefine who and how will be the heading the organizations that and all. And regulatory sequencing. Secure SEBI CCA notes parallel to the lender settlements to avoid gun jumping. Till we need not wait for the last minute. And there is a cultural fit also. Cross-border deals need India-specific advices. It was a shock to me. In fact, see, 60% of the failures basically due to the cultural mismatch. It's north-south or what you can say, because I will not diverge into details, but 60% of the M&A failure is to cultural issues. And this is the third one. This is a very interesting for you. In 2019, TI Group has acquired a near bankrupt company, CG Power. And Vellayan Subbaiah has called N. Srinivasan, who was a government nominee of ILFS, who is what we call the restructuring and recasting master. He called one day and given veto power. You take the company to the next level. And they have trusted him also. So there also a lot of complaints issue was there. So entire balance sheet was recasted. He has struggled a lot. In fact, it was during the COVID meeting. Most of the meeting was done through Zoom only. And he has written a book. You will find the detail of it, which was recently launched in 15th of December only. See, based on the what you call that MCA's request, or Nirmala Sitharaman has asked for the what you call that document. If any document regarding this what you call that success case is there, you get it and incorporate as a precedence. And they have approached Srinivasan, so he doesn't have any documentation. So in the form of the book, he has written it, how he is negotiated, which will deal it in detail. So a book called Great Revival by CG Power's comeback from bankruptcy to a 10 billion company. A powerful business turnaround story on leadership and crisis management. This was released in 15th December 2025. Written by Natarajan Srinivasan, the former MD and CEO of CG Power and long-time Murugappa Group executive. This book chronicles one of India's most remarkable corporate turnarounds. He has taken over a literally bankrupt company. In late 2020, amid the COVID-19 pandemic, Murugappa Group acquired the forget CG Power, once an iconic 80-year-old company, engineering firm, which is plagued by a lot of issues, accounting scandal, funds diversion to the tune of 3,000 crores, massive debt over 2,600 crores, in great stalled operations, and regulatory investigations is also there, eroded the total trust. The key elements includes financial restructuring, recasting the 5 years of distorted accounts, negotiating settlements with 14 banks including significant haircuts. And how he has done it? He has paid the MSME loan immediately. He got the stake sale of 800 crores, and with the consortium of banks, SBI is ready to fund 800 crores. So with 1,600 crores in his hand, he started paying immediately, within a month, all the MSME debtors was clear. And later on, with hard negotiation, there was a haircut of 43%. 43% haircut of debtors, total debtors of 2,600 crores. He was able to negotiate roughly around 1,300 or 350 crores was negotiated, the final dispute. And one more he was able to restore the employee morale. Vendor relationship, we used to interact with each and every vendors, and thereby was able to maintain the confidence of everyone. Restarting plan, and immediately the cash flow he was able to generate cash flows and receiving dividends after 8 years. Okay. So main thing is that he used to respond to each and every mail or WhatsApp during odd hours also. So that was the connect he is having. And on his positive part, Murugappa Group has given a veto power without any interference. And the second part is that most of the important critical employees are continuing even during the period of turmoil. Within 30 months, CG Power turned to profitability, regained the market share, saw the market capitalization surge past 1 lakh crore, approximately which is around 10 to 12 billion US dollars by late 2025. Making it as one of the fastest turnaround in the corporate history. This is what Nirmala Sitharaman wanted, was taken some interest in that. This one asked MCA for documentation. That is why he has written a book. I think you can go through the book. This is a practical skill and tools. I am not an expert. You people are the expert. But major what you call that thing is happen, especially for the merger is merger as far as the balance sheet are concerned, is the valuation of intangible assets. See, I worked in an what you call that IT industry. I know how they have what you call that reverse a certain part of expenses. and they will capitalize in the form of called product development costs, some content development. And ultimately, within after 3 years, if you are not able to receive any income, there is no outflow. We have to write the entire thing off, which many of them are not doing. And finally, for the students or this one who was pursuing chartered accountants, this thing, the merger and acquisition area is one of the, what we call that, bright area for India. Transaction advisory services, basically, big four means Deloitte, Pricewaterhouse, E&Y and KPMG. There is a lot of opportunities available for you people. Transaction advisory services, financial due diligence analyst, associate valuation specialist, transaction advisory manager. Key activity: buy side, sell side, due diligence, financial modeling, identifying the risks, post-merger integration and advice. Direct exposure to high value deals. Many freshers start here post articleship. Basically, these posts are available in Mumbai, Delhi, NCR, Bangalore. Other prominent firms, Grant Thornton, BDO, RSM India. There might be more. In fact, you people know it. But these are all the things which is known to me. Mid-tier Indian terms called Chia Chadha Company, Nanjia Anderson, Devan PN Chopra and Co., which offer M&A, due diligence and valuations services. So you can choose as a career path, as a transaction advisory, financial modeling, and what you call that, DCF, discounted cash flow. Investment banking and boutique advisory is one of the opportunity. Translation to M&A execution, deal sourcing, pitch books, IPL linked to M&A. And there is an opportunity in global banks also. Prestigious, limited front office, JP Morgan, Goldman Sachs and Morgan Stanley and Citi. Indian domestic boutiques prefer for CS. Basically, they will hire more. See, Kotak Investment Banking, Avendus Capital, Ambit Capital, and A3 Capital, Centrum Capital, CD Advisors, JM Financials, which you can find the roles of associate, valuation and modeling and negotiation and support. And then PE, what you call the venture capitalists and fund houses. Focus due diligence, investment analysis, portfolio management, value creation firms, KKR, Blackstones, these and all are there. Investment banking, deal sourcing, and corporate in-house roles. Big company can hire in-house M&A professionals within themselves, probably like Reliance, that and all. Independent practice or boutique consulting, niche services, valuation reports, transaction tax advisory, fairness opinion, due diligence, firms, advisors, there are many in fact, PW consulting. These you can opt for potential high earnings from specialized deals. This will be ideal for senior CS. And networking and modeling skills with 1 to 3 years of post-calibration experience boost the transitions. Forensic audit in M&A, this is a very important area now. So you are the best people to detect frauds, when, where it's and how it's happening. As I told you, the valuation of asset, tangible, intangible asset is a major gray area. And tax advisory for M&A, domestic, both international term, includes transfer pricing also. And regulatory complaints like SEBI, RBI approvals to cross-border deals. And skills and progression tips, entry level. Start with Big Four transaction services during the articleship for deal exposure. Mid level. Build financial modeling like discounted cash flow, valuation expertise, network on LinkedIn. So you can visualize the what you call that future valuation and make a discounted cash flow in a conservative this thing. Senior level, move to boutiques to PE for deal execution. CFA, MBA and help for front office roles. Basically, there is a demand rising M&A. As I told you, there is a forecast of 30% increase in the next year in M&A activities, which we can expect more inbound also. So, in short, M&A offers dynamic, high reward careers for CA in India, blending accounting rigor with strategic finance, like Big Four transaction advisory, remains the strongest pathway to the most, for the most. Synergy, this is the sectoral consolidation and innovation. This is a general recommendation. Synergy realism. Quantify cost savings and revenue uplift assumptions. Stress set synergy, timelines, and integration cost. Intangible valuation value. Technology, customer, and IP, intellectual property quality. Quality, as I told you, this what is basically in IT and services industry, whatever called is a product development cost. There is a lot of what you call that. See, on the other hand, you are parking some part of the expenses and your capitalization. See, this in my early organization, I attended a scrutiny in fact. So, IT officer didn't ask anything, but when it was funded by NSDC, so they have asked questions in fact. Your employee number is 100, which is improved to 120, but your cost is, how come your cost is reduced? Then comes these questions. So that was a grey area. Intangible assets, AS 113, you should be fair enough. What is fair, that is up to you in fact. Tax treatment review, amortization schedule and capital allowances. Align tax planning with evaluation and positive structure. And then cultural fit. As I told you, 60% of the deals are being called off due to these cultural issues. Include what you call that retention cost in the integration budgeting also. This more or less the practical flow. See, identify, quantify, validate, monitor. Due diligence can empower you. Improve audit depth. Identify the hidden liabilities and synergies. Valuation deliver robust defendable valuations. Use the deal benchmark and modes to support pricing and negotiation. Compliance, navigate regulatory and disclosure requirements. Advice on approval, reporting and tax implication in transaction. Business development position. CA as a strategic deal advisors drive M&A led growth advisory, mandates and client retention. This enhanced due diligence and risk assessment also is a major part for it. Red flags to surface early. Unexplained revenue cost spikes. Legal breaches in loan defaults. Subscriber or customer churn trends. Related party off-balance transaction. Forensic review of review of financials, related party on-off balance transactions, material discrepancies in the financial statement, rapid management turnover, complex revenues recognition features significant contingent liabilities, ratio checks, stress checks, profitability, liquidity and leverage ratios, scenario ratios test for downside cases, substrate, lifetime value and churn impact, and legal sensitivity under stress impact. Documentation audit trail best. Retain the working papers and the decision logs. Record forensic findings and remediation step. Document integration and redress indicators. Materials evidence to reduce the cost merger disputes. See, these are all the ways to monetize the merger and acquisition as an individual. See, as an audit alone, this one, your scope is limited to audit and F&A also. If we combine the what you call that with M&A advisories, first your clients will be benefited. Everything they will get in a single place. You will get it, all your advisory services. Regulatory mapping across CCI, SEBI and NCLT. Identify the required approvals, threshold and filing triggers. Prepare open offer calculation modules. Standard template for pricing, threshold and triggers. Draft clear conditions and precedents in agreement. Specify timeline, regulatory clearance and responsibility split. Early management with regulators and stakeholders, engagement with regulators and stakeholders. Pre-filing consultations to reduce the approval risk. Standardize the stakeholder disclosures and their filing. Templates for timely mandatory disclosure and notices. Mandating a regulatory filing timelines tracker. Monitoring statutory guidelines and escalation points. These are the benefit, what you call that matrix. By audit, forensic, what you call CA transaction advisory, identify the hidden liabilities and revenue and quality risk. Perform targeted vendor and contract review flag, contingent liability, example validate Ultratech Siemens vendor contracts for warranty exposure. In case of valuation specialist, financial advisory, arrange the valuation with the market multiples and deal synergies. Build scenario models factoring synergy capture and downsize the what you call that case. Example, quantify the C synergy uplift in subscriber revenue forecasts. Compliance, regulatory and compliance. ensure regulatory approvals and tax structure robustness, map the approval timelines and optimize tax structure, prepare filing packs, example, prepare SEBI and competition, filing checklist for large media deals. Business growth, strategic advisory, CFO support, translate deal rationally into growth metrics and KPI. Define 12 to 24 month KPI, integrate reporting and post-merger tracking, example set subscriber retention, and ARPU targets after the media consolidations. Convert finding into actionable delivery in short. So this is the roadmap. DCL model assumption to documentation and sensitivity, and comparative key assumptions, comparables, documentation and sensitivity, and the valuation expertise, methods and CA application, transaction, key assumption, documentation and sensitivity, and valuation and expertise. That is actually the compliance. So there is disclosure, this one, valuation approach and synergies, consistency in reporting. So in short, the Empire Builder Toolkit for India is in intent contest, mastering the art of making M&A deals required multi-dimensional toolkit. Strategic vision, seeing the combined entity not as a sum of parts, but as a transformed market leader. Financial engineering, leveraging equity, debt, and innovative structure in sometimes a volatile capital market. Regulatory foresight, building deals that are likely to pass the scrutiny and align with the national priorities like Atmanirbhar Bharat or Viksit Bharat, whatever it is. Cultural choreography. So managing human capital, promoter egos and organizational ethics with sensitivity. And this integration rigor, having a 100-day plan to capture synergies in a revenue cost and technology without using the momentum. Ultimately, in India, vibrant, complex economy, M&A is a high-stakes canvas wherein the art of deal-making is perfected. It allows companies to compress time, conquer new frontiers, and assemble the desperate pieces required to build not just a larger company but a resilient, multifaceted and enduring business empire. The everyday company grows linearly. The empire builder uses M&A to grow geometrically. And once again, thank you for the opportunity given to me. So hope you have some points for takeaway. Any questions on this? Once again, thank you for Manjunath sir.
Thank you, sir. On behalf of the management committee, I extend my sincere thanks to you, sir. I thank once again for sharing your valuable time, experience and guidance with us. We are grateful for this learning and experience. I request Chairman Manjunath Hallu to present a memento to this program. Thank you, Chairman. I thank one and all and also wish a prosperous new calendar year 2026.